What is today?
Banange kati nkomyewo ozamu atuuse banange rodine yatuuse mukomewo mujje tutandika okukola aya teri amanyi wabajjamu wabaire
Never surrender.
Ekintu kiba kitandise muganda wange subscribinga likinga ate era commentinga okwawukanako ku bulungi omulala olwaleero bano baze bangi nnyo nga bakifeesi balimu ba mirundi ebiri kkirize tugaane. Kale bannange kyekyo ekiriwo kati esango banamawulire abamu twenyiga abamu bagenda kutuula kuwadika sukuti
sokoyingireko walikona
Ribazi lwaki onyigiriza walimu kuonyigiriza kale bannange musabuscribinge mulaikinga ate era mukomentinge tuli live mu kkooti bannange kkooti tulaba kanso atuuse lord mayor maze okuba nti ayingirawo abantu bangi era nga bwe mbagambye omulundi guno bakifeesi tuliramu ba mirundi ebiri aba state n'abalala kati kyekyo ate nga ajja kubeeramu jamuwulire Tumulowooza ekikonde essaawa ina tekitandika. Abanange bimbega biri muno eryo kimbega kyolaba ki?
And we need to.
Banange tutandise ekintu ekikonde ensaawa yonna kiva batandise okuddayo bambega oyo mbega mukazi. Oyo mbega gawava okujjayo mukyala. Tugenda kwenjayo mpola mpola. Ensaawa zino bagambye leero bakifeesi bali mixed, mulimu aba state n'aba bano aba PFF ojawulira. kale oli ku extreme media yugi subscribe nga like nga tera commenting nga tuli live but webale kusema Evans Oyo state antwerp state oyo oyo afunana y'omuwaabi eriwawo ewakanso birivumbuka kanso birivumbuka wamulabye atuuse
Banangeria tetumumanyi naye afuluma apande
olwaleero kyandiba wamukyanjawulomu kale bakanso beebo abatuuseewo kati esaawa zino okujjako Martha Kaluwa sinamulaba birivumbuka wuuyo oyo birivumbuka birivumbuka n'ekanso wa Besigye Semujju nganda wuyo naye ayingiddewo Semujju Semujju nganda zange muno omusango leero muno baaba mulimu bakifeesi Saidi ne Saidi mbabuulidde mulimu bakifeesi abavudde mu bano bakifeesi b'ekibiina abawagizi ba Dr. Kizza Besigye ne babeeramu bakifeesi ba state naye bano abawagizi ba Kizza Besigye batiisa maama naye nga musabu tugenda tetusobola kwenyiga nabo tugenda kukwata luta ebifaananyi.
Kwamina tewejja naye bwe tutuula tobeera mu kifo kimu kati eno badde onoonyayo otulinnya
banangira ebirala osobola okuseeka oteekako kasente ka data kunambeezo zempiniizeewo okitegeera oteekako ka data kunambeezo zempiniizeewo zazipiniizeewo ezo ziri mu comment ziri mu mannya si mu bubi mu bulungi.
epj fax mumuwe ku ssente ne pj fax mumuwe ku ssente naye ali live naye temumuvuma.
Ekikondo lwaliro luno tuli mu kisuubira ng'era seginezeyyo lwaliro setulitayitira yabona bemanyi beetegedde tibakifeesi kyekyenjawulo ekiriwo olunaku olwaliro bakifeesi balimu bandundi 2
muli bakifeesi b'ebibiina
mulimu bakifeesi b'ekibiina ebibiina ebimu kwotadde n'abasiteeti bayinza okuba muli bali olwekiraga tebagenda kuyimbira
kwekironi kati
nzira bita
kwekironi
Mata Kaluwa uyata Oh, your council, Mata Kaluwa Senior Council.
kali nje nkole nte balamu
kola kale ajiriko banange subscribinga musubscribinga Tule live Kkooti na Kawa Kkooti egenda kutandika anytime from now. Senior Council Martha Kaluwa amaze okuba nti natuuka okuva e Kenya ne Road Mayor mwali mu kizembe abakifeesi saidi ne saidi malaba bali era uno Kkooti ejja kuwooma tulinda mulamuzi ne Dr. Kiza Besigye. Kasifa Poli commenting out there, no? Banang team Extreme Media, balang suka ngoli mu team Extreme Media group, WhatsApp group, mwabala okuba nti okumutobererera nga gye muli Trisha oba kwoli team extremely kometinga wano obanga gye muli mwabala okuba nti mujjumbira kale omusango gwenda kuba gutandika anytime from now omulungi ali ku extreme media yubi basaba busabe video lyokka like esobola okuba nga edduka omusinde nga gwayiriyiri ate obwobwe mutugo ogusosotola wano ku extreme media yubi tokubawo nga tosubscribinze making sure nga oturninga on ka notification bell awo beera updated ku buli kimu kyetukutuusaako wano oturninga on ka notification bell after subscribing awo ogenda kufuna buli information bwetuba tuteekayo bwetuba tugenda live ogirabirawo okifuna mangu notification yeeyo so turninga on ka notification bell
video kifaananyi
For 3 weeks.
kale Dr. Kizza Besigye ali mu kuleetebwa kasobola bakusajja obwo obwa SFC kati bano abatuuka leero extreme media yuge afande onagenda kwenyigawa onatupeeti
katwenyigemuko pena tukole kaliteekawo
ate bazinikano ka sitayiro beesi by'obutambaala bakabuteekako kati era bwe bagenda okuzuulira ani wa Dr. Kizza Besigye ani atali wa Dr. Kizza Besigye bakifeesi abali mu baabo batuuse.
We shall never, never, never surrender. 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 Never, never, never surrender.
Baba owulidde omuliro, muwulidde omuliro oguli eno.
Let's joy. Let's joy. Let's joy. Reading God. Excellency. Run. Cha.
The other one, so
Case number 8 should confirm that this Uganda versus Ghana. The Besigye, Hajji, Obed, Lutale, and Captain Ola.
May it please your worship. Richard Kumbuka, Chief Secretary for Prosecution. All accused persons are in court. For accused senior counsel, Mark will introduce the defense.
Please, Your Honor, my name is Martha Karua, Senior Counsel. Leading the defense. Together with Arias Rukwamo, FJ Mpaka, Katumba Apollo, Proscovia Kunehira, Sekajo Abubakar, Sekajo. I'm pronouncing the Kenyan accent. Aaron Farouk Kamleger, Bayan Turinawe, Yintu Michael, Quadarak Isaac, Katuswa Tobias. That is for the first and second accused. And for the third, Mr. Simon Subuga.
Thank you, Your Worship. This matter is coming up to jail for other nation. However, we wish to make an amendment on the charge sheet.
Please, Your Worship. We are opposed to any step being taken by the state before we make our application, which is outstanding since the last time we appeared here. And it's a command of the Constitution, it's a command of the MCA about the next step in any of the proceedings before you, after the expiration of the mandatory remand. So we wanted to proceed with our application, Your Worship, before any other step is taken.
Proceed.
Most of that, Your Worship, we pray that you will be pleased to release A1 and A2 on bail in accordance with the provisions of Article 23 of the Constitution. My Lord, have your worship. Clause 6 of Article 23 C, where a person is arrested in respect of a criminal offense, and in the case of an offense triable only by the High Court, if that person has been remanded in custody for 180 days before the case is committed to the High Court, that person shall be released on bail in such conditions as the court considers reasonable. The operative word here, Your Worship, is shall be released on bail. That what gives this honorable court authority and mandate to invoke these powers to release the guilty persons on bail. So, Your Worship, from the record, the accused persons have been on remand since the 28th day of November 2024, well beyond the mandatory period provided for under Article 23, Clause 6, Paragraph C. This particular provision is reinforced by Section 76 of the Magistrates Courts Act, which reads as follows, if it may please you, Your Worship. If an accused person has been remanded in custody before his work trial commences, in respect of an offense punishable by death, for a continuous period exceeding 180 days. B, in respect of any other offense, for a continuous period exceeding 60 days. The magistrate, before whom the accused person first appears after the expiration of the relevant period, shall be released, the magistrate, before whom the person first appears after the expiration of the relevant period, shall release him or her on bail on his or on recognizance, notwithstanding that he or she is accused of an offense referred to in Section 75, unless one, he or she has, prior to the expiration of that period, been committed to the High Court for trial. Excuse me. Now, Your Worship, from the record, the accused persons have spent over 110 days. That's a fact which is not controversial. And it's also well canvassed in the affidavit of Queen Hira Proscovia, which we find on record, to bring out the history of this matter and the chronology of the events, right from the time the accused persons were kidnapped from Nairobi on 16th of November and taken through the processes before the General Court Martial on the 20th day of the same month, November 2024, and remanded to Zira, where they have been languishing up to the present moment. All those particulars, those facts are borne out in that affidavit, are brought out in that affidavit, which is not rebutted in any way or controverted. Your Worship, on record, on the 31st day of January, the Supreme Court directed the General Court Martial to cease any trial of civilian cases, and that all those matters be classified to the ordinary court, to the conventional courts, the courts of judicature. And that is the genesis of this matter, and that's the reason we are here. So that is in the chain of the events, right from the time of kidnap to formal charging or indictment, and then subsequently remand, and up to the present moment. So now, Your Worship, here, there are two things we need to emphasize here. After blocking 180 days on remand, two things here are fundamental. Number one, this magistrate court cannot take any other step except for handling the proceedings relating to the release of the accused. No any other step. This honorable court cannot in any way proceed with issues to do with amendment of the charge sheet or any other action be taken except to issue an order of release. In such conditions, court may deem appropriate. That is number one. The second one, have they been committed before the expiration of the 180 days? The answer is no. And this is the spirit and letter of section 76, paragraph B1. Unless he or she has, prior to the expiration of that period, been committed to the High Court for trial, prior to the commitment. So there has not been any committal before the expiration of 180 days. Even if there is any committal proceedings to be taken in the future, it doesn't post the jurisdiction of this honorable court from going ahead in the mandatory period. Second, the proceedings that may be considered later would not operate as a bar for court to proceed with this command of them. We'd like to ask this honorable court, Your Worship, to look at the spirit of this particular provision, why it was enshrined in this, why it was put into the Constitution, and it was couched this way in section 76. Why this particular provision was couched? To stamp out persecution, impunity. It's intended to stamp out impunity and persecution. When you look at the provisions of Article 43, the framers of the Constitution we arrive to that fact that the state may exceed what is actually within the limit of what they have powers to deal with, and descend into the realm of persecution. And that's where we are now. That's the limit, the reason there was that limit of 180 days, and the court was given those powers that this, once the state has failed to take steps to commit the accused persons within 180 days, first appearance before you as a magistrate. Don't do any other thing. Please just consider releasing the accused persons. And that's what we are asking for your worship. This honorable court should accomplish or be an accomplice in the persecution of the accused person by the state. So the only thing that should be done at this stage is to release the accused persons on such conditions you will be in court. We do so very much.
Your worship, if I may add, just for emphasis, Your worship, again, Article 23(5)(c), the command of the Constitution, says shall, therefore does away with the ordinary bail application, which is made that allows for a discretion. So it is a constitutional command. What the court ought to satisfy itself is that the offense is tried only by the High Court. And that the persons who is the applicant have been on remand for more than 180 days before committing. So I join issue with my senior colleague, Mr. Lutale, that the committal per se does not take back time to nullify the 180 days. The 180 days are constant. Two, Your worship, is that the 180 days referred to in the constitutional command do not start to run from the date when the applicant is arraigned in the court before which the application is made. I'm saying that the 180 days, upon which bail becomes mandatory, are not counted from the date when the applicant or the accused person was arraigned before court, before which the application is made. I'm mindful of the decision of the Supreme Court. The Supreme Court directed a transfer of the files. What I'm trying to say, Your worship, is that the process from the court-martial to this court is continuous. There is no break, so that the proceedings before the Court of Appeal, for the court-martial, are not taken into consideration. So when we speak to the 180 days, Your worship, the court must take into consideration the date of remand by the General Court Martial, because it is also a court under the Constitution. So that article, Your worship, again for emphasis, says in case a person has been remanded in custody. It doesn't say, it envisages that the remand can be made by any court of law, or any court as established by law, or which the General Court Martial is just one of them. So the argument that may arise from the prosecution that the proceedings in or before this court did not commence or commence this year and therefore cannot 180 days does not hold. Court takes into consideration the time when the remand started to run, count the 180 days. And Your Worship, there is a view that perhaps in matters or offences tried only by the High Court, the Magistrates' Court should not grant bail because the matter is tried by the High Court. Your Worship, in the current constitutional dispensation, the Magistrates' Court is empowered to grant mandatory bail. Your Worship, it's a common fact that the Constitution applicable in Uganda was promulgated in 1995, so that decisions made thereafter bear in mind the constitutional order of the day. Your Worship, in Uganda versus Kesimana Rosemary, the Honorable Mr. Justice FMS Bonanted, as then was Kesimana Rosemary, its criminal revision cause number MSK -00 CR CV -0013 of 1999. I cite it because it is the current dispensation. Because in that case, again, Your Worship, the magistrate had declined to by the High Court. Your Worship, I beg to read and I'll avail a copy what the Honorable Justice Bonanted said. My Lord, it is the Worship, it's the highlight at page 13. So before I take leave of this case, I must say that courts cannot escape the blame for this unhappy state of affairs in the criminal justice system, which has no remorse for caging up people in penal institutions for unjustifiable periods of time. It appears that magistrates' courts to which accused persons are first produced before committed regard themselves as no more than, should not regard themselves as no more than assembly line of conveyor belts run by the prosecution. For years on end, the court is content to record endlessly adjournments, etc. But the point that my Lord, the judge said at paragraph 39, that even though a magistrate's court has the jurisdiction to try capital offences, accused persons such charges are brought before it to ensure that, among other things, the accused rights are protected. The courts must be vigilant in doing so by consistently requiring the prosecution to provide information regarding the investigation. What we are pointing out here, that the constitutional command says that once the accused person is emphasizing their rights, once the matter is before it, even for capital offences, this court cannot fail not to have jurisdiction on the ground that the offence is of the capital nature. In Article 23C, therefore, the accused persons contained that they have been on remand by order of the court so established under the Constitution, the GCL, for a period exceeding 180 days. If I count well, Your Worship, today there should be 196 or thereabouts. And that the matter which is before this court now is because the accused persons are exercising their right to mandatory bail as commanded by the Constitution. The onus of the court is, upon being satisfied that the 180 days on remand have elapsed, is, as the provision says, that person shall be released on bail on such conditions that the court considers. Your Worship, we are mindful of the fact, and we were told before, that there are practice directions regarding bail applications, or bail for that matter, in magistrates' courts, which were handed down by the principal judge, in regard to capital offences. Your Worship, those practice directions are not in respect to mandatory bail. They are in respect to what I would say, for want of another description, ordinary bail, or bail in ordinary circumstances. In this case, the reason why the Constitution makes a specific command is that the state is expected to have wound up its investigations and made a committal in 180 days. In any event, Your Worship, the practice directions of the principal judge and even Chief Justice cannot override the express provisions of the Constitution. We just wish to remind the court, and we are aware that the court is already aware, that the Constitution is the supreme law of the land. Your Worship, Article 2 of the Constitution is clear. Under the subheading Supremacy of the Constitution, states that the Constitution is the supreme law of Uganda and shall have binding force on all authorities and persons throughout Uganda. So, Your Worship, that means that the Constitution and its provisions have binding force on this court, on the persons of the Chief Justice and the Principal Judge, ordinarily in their individual capacity, and also in their official capacity, exercising their powers as the Chief Justice and the Principal Judge, respectively. So much so that the practice directions they pass must be brought in conformity with the Constitution. They cannot surpass or override the power in Article 23, which my land colleague, Mr. Obed, Senior Counsel, reiterates the prayer that 180 days have elapsed, and as the defense, we shall happily receive the conditions for the mandatory bail, because it is a command that it must be granted.
my colleagues will submit an authority. After me, then senior counsel will close our presentation in this application. But I want to start with or just emphasize the practical matters. The date of remand and custody was 20th of November 2024. Vide General Court Martial, criminal case number UPDF stroke GCM stroke 040 stroke 2024. The state is aware of this fact because they have said so. In an affidavit before this honorable court, the state, through its detective IP or Benedict, they acknowledged that the respondents, namely the accused, were previously charged before the General Court Martial at Amajje. The application was filed on 5th March 2025, and it is the application for accessing the court records. Yes, the telephone particulars, which Your Honor is on this honorable court's record. I think Your Worship, you just interjected me. Allow me something.
I have not said the word and you're panicking.
Just speak.
Yes, you can't stop me from saying the thing.
You have.
Relax.
I hope you don't commit another one. So what I'm saying is that the document which Baletedwa is referring to has not been taken down. And therefore, it cannot form. We cannot preempt a document in an application which has not been had and use it as evidence in your application.
Your Honor, before I was rudely interrupted by the representative from the government of Uganda, I was going to draw your attention to, among others, in this very court, criminal miscellaneous application number 001 of 2025, in which the number 01 2025, in which the state made reliance the affidavit of detective IP Obed Benedict, who saw that he's aware not only that the accused were charged before the General Court Martial, but that is also one of the people who are charged with investigating their matters. That is the date of custody or remand in accordance with the Constitution. Your Honor, the plea for mandatory bail that my comrades have emphasized pursuant to Article 23, Clause 6, Paragraph C, is intended, among others, to ensure that the accused get a fair hearing. The only way people can effectively defend themselves
who have spent 6 months on remand is when they have liberty to defend themselves from home, and also to ensure that their trial and detention is not too lengthy. Your duty as this honorable court is Clause 1 of Article 20 of the Constitution reminds us that the right to liberty is inherent. It's not a gift of the state. Clause 2 of that article is the effect that this court, the office of the Director of Public Prosecution, and other people should not only respect and uphold the right to liberty and other fundamental rights, but also promote them. What we do here this morning should be seen to promote the liberty of Besigye, Obed, and Dennis. It should not be seen as to frustrate their liberty. And should the state get wayward and try to frustrate that liberty, it involves you as the judicial officer presiding over this matter under that article to rein in the state and ensure that it's back on the track, the constitutional track of guaranteeing that liberty. These provisions of the Constitution are very important because the Constitution is supreme. The supremacy of the Constitution is underscored by Article 2, clauses 1, 2, and 3 of the Constitution. So any other speech, any other law that tends to negate the constitutional entitlement to liberty after 6 months should be seen as inconsequential to the extent of that. And I say this in anticipation of some speech that may come after here relating to some practice directions, which are in fact a challenge of the are being challenged before the Constitutional Court. But even those guidelines themselves acknowledge that the Constitution comes first. At this juncture, my young brother who wanted to give us an authority to give this, then our closure will come through.
Your Worship, for purposes of record, I am true now. Your Worship, I want to join issue with my learned brothers who have submitted on the powers of this court to prevent this person's mandatory leave, but only to add an authority for when court takes a view that the authority that was submitted is of an earlier date. Your Worship, I ask much of that. For if court takes a view that the authority that was submitted is of an earlier date, Your Worship, formally in 2022, the Honorable Justice Biaruhanga Jesse, sitting at Masindi in the High Court, in Nyangoma Flavia versus Uganda, Nyangoma Flavia versus Uganda, in criminal application number 7 of of 2022. At page 3, paragraph 4, had the opportunity to say this, and I will quote in verbatim. I have perused the lower court file copies of the lower court copies of the remand warrants and the applicants and 7 others. The remand warrants are to the effect that the accused persons were remanded first in prison on 12 November 2021, save for Kato Francis, A8, who was released on bail on account of being a juvenile. Since 12 November 2021, when the applicant and the 7 others were first remanded to prison, more than 180 days passed before the committal to the High Court. It follows, therefore, that neither the magistrate's court nor the court that has neither the magistrate's court nor this court has any discretion not to grant them bail. It was a violation of Article 23, Clause 6, Subclause C of the Constitution as amended for the magistrate before whom the accused persons first appeared after the expiration of the 180 days remand period to decline or refuse to release the accused persons on bail, for he or she had no discretion to do so. Your Worship, if I may add, is that such a decision of the High Court has a binding authority nature on this specific court. Your Worship, the Honorable Justice Jesse Yarohanga took a view that the magistrate does not have discretion to deny an accused person who has appeared before him or her after the lapse of 180 days. For avoidance of doubt, Your Worship, the accused persons were charged with murder, which is a capital offense, and only the tribal and the High Court. Your Worship, my comfort in that authority is to the extent that this decision is of a similar nature as the case we are faced with today. And therefore, I reiterate the area prayers of my learned brothers that the accused persons are entitled to be released, and keyword entitled to be released on mandatory bail by this court. And this court has no discretion to deny such an application. Much obliged, Your Worship.
Please, Your Honor, I'll be brief, but before I advance my 2 points, I just want to tell my learned friend, the prosecutor, that it is unfortunate that he would refer to the previous incarceration of Aaron, whether in jest, knowing very well that it was before a lay court, because he said that he may once again be deported. It is not a fair thing to do, and it cannot be taken in jest. I'm requesting us to move.
Can we create the way maybe?
Excuse me, please make way so that you can sit down.
Yes, it is.
I was just expressing regret that my learned friend would joke with liberty of our colleagues taken away illegally, as the Supreme Court found. But having said that, I want to commend my team. They have demonstrated to your honor the law of bail and the fact that the court has no discretion whatsoever. But we also want to refer you to one more case from the Supreme Court in the Foundation for Human Rights Initiative versus the Attorney General, Solicitor General, Constitutional Appeal number 3 of 2009. Yes. Katurebe CJ, Foundation for Human Rights Initiative versus the AG and SC. Constitutional Appeal number 3 of 2009. The decision is by Katurebe CJ, as he then was. He held that when an accused person applies for bail, the court retains the discretion whether or not to grant bail to the accused person, which discretion has to be exercised judicially. But now comes the most important. The only time when the court has no discretion is when a person has been on remand for the period stipulated in Article 23(6)(b) or 23(6)(c). In those situations, the court shall grant bail. I suppose the court retains the power to determine the terms of the bail. In other words, this is a Supreme Court decision, and this honorable court is obliged to follow not just the High Court, but the apex court decision. Now my 2 points. I want to refer you to the obvious, Article 126 of the Constitution of Uganda, which clearly states that judicial power is derived from the people and shall be exercised by the courts established under this Constitution in the name of the people and in conformity with law and with values, norms, and aspirations of the people. In other words, the framers of the Constitution and the people of Uganda put the trust in judiciary to adjudicate on these matters. I am therefore urging your honor in exercising your judicial power and in giving the ruling in this bail application to abide by the values of constitutionalism and the rule of law, and in the name of the people of Uganda, grant our clients bail. My learned friend will be submitting on record on A3, but they have a similar history of detention, not exact the same period, but anybody who has finished more than 180 days, you are obliged to release them pending their committal. I'm also reminding the court of the audience that the scales of justice must balance. And in Article 21, equality and freedom from discrimination, we come before you as parties with equality of arms. Therefore, the prosecution and the defense are equal before you. None is superior. And none should come with the assumption that they carry more weight. Therefore, it is your duty to demonstrate, because justice must not only be done, but must be seen to be done. That the scales of justice are balancing, and that you are availing all the parties, and in this case, A1 to A3, the due protection of law. And the law on bail is for their protection. So we urge you to exercise your discretion to give them bail on such terms as you find fit, to enable these proceedings to continue when they are free, because they have stayed in custody for the maximum period allowed by law. I yield to my colleague, Speaker for April.
Worship. First, I'm going to issue with the submissions of Senior Counsel Justice Kwabo, Frederick Mpanga, Martha Karua, Reverend Kiza, and Brian. We contend that Captain Ola Dennis has been on demand exceeding the mandatory 180 days. Your Worship, Section 76 communicates to you and says that what happens when they present Ola to you after the elapse of the 180 days. You're only left with one option: to release Captain Ola. These are the situations where you cannot release Ola. If he has been committed to the High Court, Your Worship, Ola has not yet been committed. Or if it is in the public interest that Ola must not be released, Your Worship, there isn't any evidence that Ola is harmful to the public. Your Worship, then back to Article 126. Exercise of judicial power, which is derived from the people. Clause 2. In adjudicating cases of both civil and criminal nature, Your Worship, these cases of criminal nature, the courts shall subject the law, applying the following principles: that justice shall be done to all, irrespective of their social or economic status. My Lord, that Your Worship, Ola is a soldier. We pray that he also enjoys the liberty that is granted, couched in mandatory terms under Section 236C of the Constitution. It also further says that justice shall not be delayed. The framers of this Constitution were privy to the fact that criminal prosecution is delayed. That's why they came out with a position that when an accused person is remanded exceeding 180 days, the choice is limited. And Your Worship, I'm appealing and praying for your choice. Maybe push me to the conditions that may be reasonable to grant Ola bail. Ola is a family man. The father, actually, he has children who have to go back to school. He's not sure that they'll go back to school because their father is here. That is Ola. Any other application to keep Ola in lawful custody, we submit that it is very absurd. In fact, Your Worship, we take issue with the other submissions of the senior counsel. So,
we were not aware of the affidavit which was filed by the applicant. I don't know where the consciousness went because we have been serving each other. The prosecution has been making it a point to serve the defense each and everything that has been filed. That said, it is imperative of your worship that you grant us 1 hour standover. We look through that affidavit and we make an informed response because we do not know what it contains. 1 hour. Look through it. Because it seems to have a lot. And it would be just fair and just the prosecution for the respondent looks at it. Also, we haven't been my colleagues have been submitting and they have been keeping authorities to themselves. They are the people who are actually singing fairness, but they are actually not strong. Every authority that has been talked about has not been given this prosecution. We feel that is very unfair in that regard because we believe they prepared for this application. The fact that they put in an affidavit in support, they were prepared and therefore you are supposed to prepare all the authority and also grant us an opportunity to prepare our defense in this matter. There's an affidavit of Prosecution. We haven't. And this is what we are asking for, that court gives us 1 hour, only 1 hour, because we operate as a team, the way they do. So we need an hour to look at that affidavit and we prepare our response. We're going to give it today, after an hour. And that is our plan.
What we are opposed to an adjournment for 1 hour. If he was talking of 10 minutes, 15 minutes, it would be okay. Because the only reference to that affidavit is to the date. A1 and A2 have been in custody from the 20th of November 2024. The contents of the affidavit were not part of this application because it's an application for bail. So if he wants to look at that paragraph, and I'm saying this because the court is aware that as senior counsel, I am coming from a neighboring country. I flew in today. I hope to go back later. We were in court last time. The prosecution opposed to us coming before the court the next morning. And then after I had left, brought the amended charges. If it's about fairness, let's treat each other fairly. The only thing mattering here is the date. Your Honor may give him 15 minutes to look at the affidavit. 1 hour is too much to ask.
Just to do the record.
Your Worship, before my colleague responds, the last time you were here, the court adjourned so that we make this application. The person who was present representing the state was Mr. Richard Bumbuka. So he's aware, because the court indicated we have done for your brother magistrate, because the presiding magistrate was not available, and it was made very clear that the application for mandatory bail will be made because the accused persons had spent more than 1 year. So that was the 21st, we told counsel. The other one about the authorities. All the authorities which have been cited are versus Uganda, whereby Mr. Bumbuka, representing Uganda, is a party. So it means that by default, the office which sent him argues the cases, that they are not responsible to take stock of these authorities, and armed counsel, aware of what we're coming to do, cannot be taken on to the accused persons. He was aware we were coming to argue just that, and that is why court will note that when my non-colleague Mr. Lutale asked that we proceed with this application, he did not report because he was on notice. So his belated response, perhaps, it is also courteous of counsel to appear when he's overwhelmed and concede that the circumstances are beyond him, so that court proceeds and pronounces itself on the conditions for mandatory bail. So we do not accept the 1 hour because my colleague was aware of what we
Your Worship, just like the Bible, with verses and scriptures, the Bible of justice is the Constitution, which Richard Bumbuka has had for the time he has gone ago. And I do not think that an adjournment will have amendments to the articles in the Constitution. But the article is speaking in command that these people, F3, ought to be released. Unless Richard Bumbuka is going to come and address court and inform that he's conceding that Richard Davis Ola goes home. If that is the question, I don't know. But if that's not the position, I oppose the adjournment of an hour.
Lastly, and briefly, Mr. Bumbuka Richard stated a lie to court when he stated that all the authorities that have been cited, he has not been given. Your Worship, he has an authority which I cited, it's even highlighted for him. So he's lying to court that all the authorities that have been stated have not been given to him, and I pray that he will withdraw that.
I think this is very simple. I take a notice that you have just submitted this. You have just don't you look so unfair? That I can say I don't have any authority. For sure, you are not submitted. You are not given me. But nonetheless, maybe court can take a decision on that, and then we can take that in court.
So since the prosecution says that it needs to look at the affidavit, I'm going to give it strictly 10 minutes. So court is stood over for 10 minutes.
Besigye bayinza omutta atusabe kubanga koti bava gyongerayo for 10 minutes kusigera bava gibuuza mbona ono Bumbuka ayagala kutunulako mu kipapula kino tebali mu kusoma, so koti bagyongezayo only for 10 minutes. So kitegeeza tetugenda kuvaako. Nyongera okubajjukiza nti omusajja ono aludde mu kkomera, kkirize tugaanye aludde mu kkomera ng'entakiza Besigye ne Obed aludde mu kkomera for now 6 months. Kitegeera ekintu ekyo kitegeeza balina okuvaamu mateeka, kiri mu mateeka balina okuvaamu. So bwe kyolina okukola bwekubeera kuno Stream Media UD mwena abagiriko mu likinga video eyo kiyambe n'abalala okufuna information. Oba ogilaikinze bw'oba ogiraikinze kitegeeza omulala asobola okufuna chance nti ategeera kiki ekigenda mu maaso mu ggwanga. Mwena mugiraikinge, muliko over 200, mwena mugiraikinge yambe. Evans mwebale kuba nti Evans mwebale kuba nti ogoberera Evans Media, oli wakabi nnyo. Thank you so much for always keeping it extreme media looking. If it's your first time here, don't go without subscribing. Make sure you subscribe and click in the notification bell. Obera updated ku buli kimu kituusaako omulungi agiriko. Ali abuuziza nti waliwo gwe basitudde mu kooti, eriyo gwe basitudde mu kooti agudde munnamawulire azirise collapsing kankyogere bwentyo collapsed munnamawulire collapsing kitegeera. So ne bamufulumya. He's not going to read the paper, but he's going to make a call. Other office, the Anthony General, yeah, you may be Ongodia George, what Wagambia, omusajja ayinza okuba agenda kuba essimu ye Anthony General Kiwanuka. Naye nga tubeereko attitude yayingi subscribing. Make sure you subscribe. If it's your first time here, please tuweze ba subscribers muchikole because then those numbers eziri awo numbers eziri awo sobola oteekako data not supporting embeera yonna omulungi aliko Mr. Billy Vumbuka yoyo sorry yoyo our state yoyo Billy Vumbuka yagenda okusomamu obawadde 10 minutes somamu. So all you need to do is subscribe. Tetugenda kuva Eria obadde ki so embeera bweti bweri abantu bangi nnyo mu lipooti olwaleero abantu bangi nnyo ddalaki oliyo to banange tekulaba netiwaka obadde ki kyo kiriwo oli study kale guys, that's what's happening. Ndowooza nedakika polisi yizo okuba ziri mu
okay, we'll be fine. Thank you.
Anyway, what's here? Okay, we just wait.
Yeah, be.
Ambitions are different fighters.
twagala kufunako bakanso
amateeka gannyonnyola buli situation kiki ekibeerawo. So olwaleero tubadde tusuubira nti mwami Richard Bilivumbuka omuwabi wa gavumenti akimanyi nti etteeka liri kiriya mu article 23(6)C of the Constitution ne section 76 ya MCA nti olwaleero Dr. Kizza Besigye bw'ajja mu kkooti ekiteekwa okukolebwa kuwuliriza bail application ye. So see any other thing. That's a command of the law. Kati ye byatuzaamu ate amending charges nga amateeka gannyonnyola kiki ekirina okukolebwa mu mbeera eyo olwaleero aba ali mu kumenya ssemateeka aba ali mu kumenya mateeka. So n'olwekyo asabye kkooti essaawa nnamba mbu asomeko mu affidavit gye twateeka mu kkooti mbu tetwagimuwa. Ate ng'ekiri mu kkooti si kya affidavit olwaleero, si kirayiro ekyo kye twateeka mu kkooti, nedda ekiri mu kkooti olwaleero Besigye amaze ebbanga erisukka mu nnaku 180 ng'ali ku remand mu kkomera. Ate ng'etteeka linnyonnyola kiki ekikolebwa embeera eyo bw'ebeerawo. So ono kyaleeta ekya affidavit kyasaba essaawa nnamba era kiba kikyamu. Y'ensonga lwaki n'omulamuzi essaawa nnamba agigaanye okugimuwa n'amuwa eddakiika 10 zino ze tufulumye.
So briefly in English, Counsel Mike Chin.
Yeah, today as lawyers for Dr. Kizza Besigye and Hajji Obed Lutale, we have been surprised by what the state attorney is saying, that he needs an adjournment of a full hour, because we have hinted on an affidavit that we filed in court regarding our bail application. Yet he knew, and he is presumed to know, as a state attorney, a senior state attorney, in fact a chief state attorney, he is presumed to know the law, that Dr. Besigye has been in prison for over 180 days. And the Constitution under Article 123(6)(c) of the Constitution, in mandatory terms, it directs that a magistrate court where such a person appears must release him on bail. The word used in the Constitution is shall, implying that even court has no discretion regarding that. It must release the person, save court has some few discretion there, that it might give some conditions to the accused person, but it must release the accused person. It's a constitutional command. However, the prosecutor has asked for an hour, which the judicial officer, the magistrate, has refused to grant, and she has told him 10 minutes, peruse the affidavit, and we proceed. You know why? This bail application is purely based on matters of law, both in the Constitution of the Republic of Uganda and the Magistrate Courts Act, Cap 18. So there is no way why the state attorney should begin asking for affidavits which are on court record. It is immaterial. He should confine himself to the sections of the law and the article in the Constitution. He doesn't need to delve into the Constitution. We have given court mandatory provisions of the law. So let him rebut that. Anyway, no wonder the trial magistrate has given him only 10 minutes to go through the affidavit as he wants for the sake of fairness, and then he comes back to court and we proceed. So we are waiting for him to go through the affidavit, then we go back to court.
Katikamu South, we are coming. Just a simple message for Katikamu South. Let's first.
Yeah, let me just remind my people who love me so much, people who requested me to come and stand and contest as a member of parliament for Katikamu South, people who want me to represent them in the parliament of the Republic of Uganda, that I am coming. Chintu Michael, I am coming as your member of parliament. I'm coming to stand as a human rights lawyer. You can tell that even right now I'm fighting for someone's rights.
That was even in Uganda Council.
Yeah, so njagala kujjukiza abantu bange ab'Ekatikamu South tisinaba kubeerabira nzija ku Lwokutaano naliyo ne ku Lwokusatu nabaddeyo, era nga tuli mu kwogera ku bintu byaffe ebyenjawulo ebikulaakulanya Katikamu South constituency. Abalema ab'obulenzi n'abamiitinze, so nange okusaba kwammwe nakuteeka mu nkola era nenzikiriza okujja nkiikirire Katikamu South mu parliament ng'omubaka addako 2026 2031. Tuli wano olwaleero nga bwe mumanyi omwana wammwe wa Katikamu South ow'Endejje, ndi mulwanirizi wa ddembe. Eddembe ndilwanira buli wenda banyigirizibwa eddembe lye. Kintu Michael nja kubeerawo. Gwe munnakatikamu South olonze Golodi, londa Kintu Michael kukiikire mu parliament, eddembe lyo obeere ng'olikuumye. Mwebale nnyo, mwebale.
Sakategede naye njake njagala okubuuza based on your observation, which hope can you give to Ugandans? Which hope based on your observation on what is observed inside there?
Yeah, you see, based on my observation in court, of course the trial magistrate has expressed good demeanor in court. Given her expressions and demeanor, I think she's so much inclined to comply with the requirements and dictates of the law, especially Article 23(6)(c) and Section 76 of the MCA, by simply granting bail and giving conditions. However, I want to remind all Ugandans and the entire citizenry that in this country we have laws. Some of them signed by the president and ratified. However, his word is above the law. So we do not know what type of communication the trial magistrate is going to get in this break. We cannot predict. We cannot speculate. So she may, because of the power of the state, not to grant this bail. That is my suspicion and what I think.
Okay.
Yes.
Okay, briefly in Luganda.
Yeah, nze ndowooza nti akaseera kano ke tufunyako eddakiika 10 nga tufulumye ebweru, omulamuzi bambi nze nga bwe mutunuulidde mu kkooti ndabye nga omwoyo gwe n'omutima gwe bikkiriziganyizza n'okuwoza kwaffe ne bail application yaffe kubanga esinziira mu mateeka ssemateeka ne Magistrate Courts Act section 76 MCA ne article 23 akatundutundu 6 n'akatundutundu C. So ndabye nga akkiriziganyiza naffe ate naddala bw'alabye ng'omuwaabi wa gavumenti atagala. So naye okutya kwange we kuli nti bannayuganda mwena mukimanyi nti wano mu Uganda amateeka we gali President Museveni yagasentingako tugalina naye tagateeka mu nkola ate instead agalwanyisa. So mu break eno gye tuli musiyinza kumanya omulamuzi bayinza omuyisaamu akasimu bayinza okumutiisatiisa nga bemuzze mu biraba n'asalawo ekyo ekitali mu mateeka n'agaana okuta Dr. Besigye ne Hajji Obed Lutale ekintu ekijja okuba ekimenye ennyingo eyo gye njogeddeko ya ssemateeka n'akawaayiro kali mu tteeka erifuga bamagistrate. Kati so nze ng'omu mbuusabuusa nti anaakompulayinga n'amateeka olw'okuba nti Mwami Museveni bw'atyo bw'akola ebintu tagoberera amateeka.
Esawa era kike ku mitezi weddeeko.
Council, thank you very much.
Kati banange ndowooza banange ani agambye okundigiriza olunyankole maama salaamu musumba nkogwa ekifaanani
abaleeyi abampi
aye bana maama kansooka ensabule abamaama bange ekifaanani kambasabule maama niwo nkobyo tolikolenda obeera oli kumbuuza mukaliko galunyankole
okaliko galunyankole lusoga
tena tujatandika basomesa olusogaani be ndibwe naano bukalamu manda bubande iwe sigala omande kale salamu musumba
It's okay, sir.
Salamu banange nakiike ku miziweddeyo atuba tukomyewo nakiike ku miziweddeyo Evans omusajja omuwulidde agala abantu balingiza olunyankole bannanga abantu olunyankole luyigika lyatandika obayigiza olusoga lyatandika obegereza olusoga lyantaka maze nambatwala mu besimenti eyo mbatwala eyo tukomawo ya bank temuvaako naye enjala erima Evans media enjala erima soka nkoleko era mbenze mpinizeewo nkolaako siri bulungi nange oyagala nkola pusinge enjala entandikeko nange nzirike nange enjala ennuma eko kyemukola bakomyewo Dr. Besigye yapa abo abasajja bano bannange kansobiri kumbuka tali mukulabikako is nowhere to be seen. Bayagala kulwanira ddala teyagambye agenda kulwanira ddala Evans media kyekigaanyi genda otekeko enjala ennuma Evans enjala enuma gira mugire mukwataganire benadi owata namanya Nicholas amuhangule alampa nange soke neteke mu kijwisi wali omusala mungi kitegedde ekintu ekyo sikanene nyuma yekana Jackines tokamanya Jackines iziniro kungiri town park aberu kungiri mbagane ka subscribe ne banani amataje gali Jackines mu kifo ky'amata soka oteekereko wano kaddata tulabe kuba nsinikira ngenda gulamu amata Jackines oberukungiri bagambe gye tuli muna tuli kubabotereza kasubscribing ku Extreme Media God have mercy on our man. You have to be lament watu wanagamba banange nze njala enuma era bakuba oluseke kati oluseke ekenda okuvamu oluseke lwa magezi toluluma nnyo si lwa mu bulabu ngomba okuba nti nomugoberera Extreme Media yugi subscribinga likinga atera commentinga olimbe kabaka John Paul Gikumani nga nze nasalawo okuba nti nombatuusaako buli kimu kyolina okuba nti otegeera whatever you want to know ku Extreme Media yugi tubeera tukuweereza paka kuwulira subscribinga likinga atera commentinga tukikole mwena abakiriko kuweza basubscribe 30k because we are looking forward to kuweza 30k tulina kubaleka so kuba tonna bakusubscribinga get some vibe from some of the players some of them no kwogera nga Kkooti ewedde uno waali oyo waali semujuguyo oyo naye tasobola twogera kati sawa birivumbuka oyo akomyewo birivumbuka oyo akomyewo evaniziwe bali kuba kusiima ndi waddala omukooti mansho ate ne bali muzaayo omukooti mansho nekesi baganya omuwa bayoba tujja kugenda mateeka tuli wandumani Evans Media we bali kuba ntino okimanyi kati kulwekyo soka otegeka ekyetaano sorry Lord Mayor wali and subscribe and make sure you subscribe and please click the notification bell so that you get updated Nicholas Amajje the one anange Nicholas mpa kumata siri kasiri yafuna kumata nkugambye kapana ava ku basimu ava ku basimu Antama n'okwogera yakwogera banange jengeri yagala CEO wa PJ Packets yagala kunkubirako luseke banange mukkiriza musindike Kkooti etandise tetusobola kwogera kati Kkooti etandise
May I please, since we never filed an reply, I pray for legal court to reply to the application.
We don't receive.
Your Worship, the applicants made an application under Article 23, 6C. Although my senior colleague in Pango was referred to section Article 25, which is your report for saying Article 25, but it's Article 26.
I thank you for the correction.
No worries. Their argument is that the applicants have been on remand for over 6 months. And they are premising their argument on the charges under the General Court Martial. Where the first 2 applicants, that is Lieutenant Colonel Dr. Bisazeko and Hajji, Obed Lutale, appeared on the 20th of November 2024. The defense or the applicants are also relating the same the charges that the applicants are facing before this honorable court. Article 23(6)(c), which is the basis of this application, is to the effect that where a person is arrested in respect of a criminal offense, and in the case of an offense triable only by the High Court, if that person has been remanded in custody for 180 days before the case is committed to the High Court, that person shall be released on bail on such terms as the court considers reasonable. This article is perfect. However, it doesn't apply in the instant case. Why? The applicants appeared before the General Court Martial. On charges which are triable not only by the High Court, but the lower court. That one collapses the application because the article is very clear. Only, let me repeat it, if that person has been remanded in custody, in the case of an offense triable only by the High Court. The charges the applicants were facing before the General Court Martial were not offenses or charges that fall under Article 23(6)(c) of the Constitution. In other words, it is only the charges which the applicants are facing before this honorable court that apply under Article 23(6)(c). This is a total misinterpretation of the Constitution by the defense. The applicants appear in this court, which I may refer to as the civil justice system, on the 21st of February 2025. And this is the legitimate charge which this honorable court has jurisdiction over on the 21st of February 2025. That said, even if the applicants were facing charges that are referred to under Article 23(6)(c) of the Constitution, the charges of the General Court Martial do not apply in this honorable court. Because the court martial is under military justice system. And this court does not have powers on any matter that is before the General Court Martial. The same applies to DPP, the Director of Public Prosecution, whom I represent today. So it would be irregular to bundle the two justice systems and hold the civil justice system liable for, or responsible for what happened in or before the military justice system. As if that's not enough, the charges under the General Court Martial ceased and were terminated by the constitutional ruling of the Supreme Court. In other words, DPP never inherited any charges which were instituted before the General Court Martial. DPP initiated or directed for fresh and new investigations, which are the basis of the charges that the applicants are facing. The applicants furnished this court with a copy of the charge sheet, which was before the General Court Martial, And I believe this court takes judicial notice of the charges on the charge sheet, apparently before court. And if that is the case, court may realize that the charges do not speak to each other. The General Court Martial has different charges, there are different charges, and here the applicants are facing charges which are completely different. But even if the applicants were charged with offenses which attract death, even if the applicants were charged with offenses which attract death before the General Court Martial, the civil justice system where this honorable court falls does not have jurisdiction and does not enforce the UPDF Act under which the applicants were charged. So that makes the two completely different. Your Worship, the question is, does this court have a record of the General Court Martial? And if it is true that it does not have the way I believe, then this court, where does this court get the moral and legal authority to be bound by proceedings which are not before it? We invite this court agree with the prosecution that this court does not have any moral or legal authority to consider the record of proceeding in the General Court Martial, even if it had it, because this court was not party to that. This court did not in any way inherit the proceedings of the General Court Martial. And I beg also to question, ask again, and I also ask this court, ask itself, when did the charges against the applicants, when were they filed before this court? When did this court first interact or come into contact with the applicants as a civil justice court? It is simple mathematics. It is on the 21st of February 2025. And that translates, what does that mean? Lawyers are not good mathematicians, they do not count money, but I try to count. The applicants have been in custody for 3 months and 8 days. (21st of February). So they have been, before, they have been on demand not more than 4 months. To put it that way, generally. Now, if that is the issue, if it is true, they have been on demand for not more than 6 months, are they entitled to the provisions under Article 23, Law 6C? The answer, Your Worship, is in the negative. No.
And if that is the issue, the other question is, wasn't this a misinterpretation of the provisions of that article by the defense? We invite this court to answer it in affirmative. Your Worship, we do appreciate the provisions of that article, and we would have no problem court releasing the applicant if they had blocked the mandatory fee. But they have not. This court would have assumed the jurisdiction which is over and above that it has in the civil justice system. My brothers quoted several authorities in that regard. They quoted so many cases. It is a submission that prosecution agrees with the defense that this court is by law supposed to protect all the rights of the applicants before it. But court should not also have this matter handled on a matter of technicality, as it was submitted by my colleagues under Article 126(2)(e of the Constitution. Even if the applicants, for example, if I'm to play a devil's advocate role, even if the applicants had clocked mandatory, prosecution duly noticed, put the defense, the applicants on notice that they are ready to commit the applicants. They are on notice. That mere notice ties up the hands of this court. It is our submission and prosecution that ties up this court. And any decision which is to the contrary would be administering substantive injustice on a matter of technicality. How? Because the defense submitted that Article 23, Clause 6C applies instantly, and that court cannot do anything else for as long as the accused person or the applicant blocks mandatory period. Our argument is that even if they had blocked mandatory period, the mere fact that we put them on notice that our committee papers are ready, the provisions under Article 23, Clause 6C is not a ticket to have the applicants released on mandatory bail when the committee papers are available. Because the issue then is, what is the substantive justice here? The substantive justice here is to have an expeditious trial of the applicants, which can only be done after being committed to high court. The argument by defense that, the first thing we have to do is to consider mandatory bail, let the applicants be released on mandatory bail, then the rest come later. That is the thinking selfishly. It is acting contrary
to Article 126.628, which they quoted. They took a lot of time. In fact, I'm just about 10% on the 10 minute. So it is a submission, Your Worship, that this court disregards and dismisses the application by defense on the basis that this court has no control over matters for general court martial. They have not blocked mandatory period of time. The fact that they were remanded on the 21st of February 2025. Because this application, Your Worship, is in bad faith. It is in bad faith, especially given that the committee papers are available. We are ready to commit. We have been on record several times, and we have submitted that the defense has been in prosecution to delay the prosecution of this matter by using all the tricks available, all tricks that are actually at their disposal to ensure that they frustrate the process. They should have been the people who should be agitating for an expeditious trial. But now they are speaking the other language. Because as prosecution, we believe that now that our committee papers are ready, it doesn't make sense to have the applicants released on the mandatory. It is our prayer that the accused persons or the applicants be committed and have the matter expeditiously tried, because we are ready. We beg this court to dismiss the application. They are tempted with that in this application. So,
I'll make my response first and then my colleagues will come in. I'm just we will try and be very short. One of the things is, when does the period of remand count? And I'll start by giving the court an authority which was determined in April this year by Justice Isaac Mwaka. This is application number 133 of 2025, arising from criminal number UPDF GCM 022 of 2020. Besigye applicant versus Uganda. And in this case, I will not go to the details, but I'll come to the end of it, where the court says, I find that the applicant has satisfied the requirements for mandatory bail and Article 23(6)(c) of the Constitution, Section 15 of the Trial on Indictments, case detention of over 1,500 days without trial, and committal qualifies him to be released on mandatory bail. This person, the 1,500 days being referred to, is the remand in the general court, in the court martial. So this authority sorts out the matter of whether the period of remand in the court martial counts. Number two, it would be absurd to construe the period of remand as 3 months. And I'm urging this court to take judicial notice, because these matters have been very public. Since the judgment of the Supreme Court on the 31st of January this year, the A1, A2 have been in court applying for bail, and the prosecution has refused to concede to bail. They were not released by the authorities even after the judgment. How then can the court take the period of remand under the general court martial in asylum? Before we came before this court, under what warrants were they being held? Wasn't it to the order of the state, which continued to oppose bail application? My friend cannot approbate and reprobate. He must decide which. what the submissions are, but not one time to oppose bail and say they are lawfully held, and then to come and disown the period for which they were detained as an extension of the proceedings in the general court martial. In fact, doing so is admitting malice. Because if there was no connection, then the Attorney General would have been the first to say, release them, we are now doing new investigations. The Attorney General did not do that. So the submissions of my learned colleague, the prosecutor, is actually borders on admitting malice on part of the Attorney General. The court should not be caught in this conspiracy to deny the accused persons their liberty. I don't want to go back to Article 23 because it's very clear. It doesn't say the High Court only. It says, this says, in the case of an offense which is triable by the High Court as well as by the subordinate court. These committal proceedings are part of the trial. So the subordinate court initiates and the High Court continues with the trial after committal. If that person has been remanded in custody for a period of 60 days, so if it was this court, we would have come for bail early. But because it's both, if you look at C, it's both the subordinate court and the High Court. They've been in custody for over 180 days. And it's very clear that if before the case is committed, and exactly that is where we are. We are applying for bail before this case is committed. Are we entitled to do that? Yes. And that's where we refer you to the Magistrates Court Act, Section 76. We are not doing it just because we dreamt of it. It's the law, it's written in black and white. That in respect, this is 76B. 76B A. In respect of any offense punishable by death, if for a continuous period exceeding 180 days, which is where we are, if you allow me not to read B, to go straight, the magistrate before whom the accused person first appears after the expiration of the relevant period shall release him or her on bail, shall, on their own cognizance, notwithstanding that he or she is accused of the offense. So before any other act, before any other application, including the committal, and we were not aware of the committal, we came for our bail application, it's today that we are becoming aware. So if the court were to look at who has been delayed, we were at the court martial for several months. They never commenced the trial. We've been before the civil courts for the whole of February, March, the whole of April, and this is the end of May, 4 months. Who has held the prosecution from concluding? He cannot come and infer improper motive on us. Your Honor, there is very little room left for you. There is no discretion in this matter. You must admit them to bail. But you have discretion as to the terms. Let my colleagues finalize. I'm aware that the court has requested we finish. We try to be brief. I yield to you.
My colleague has something joint to discuss. So we are organized when I come in.
Motion for the record Lordship, for to clarify to the authority that was shared that has been submitted on my senior counsel, Martha Karua, under which the High Court released the person this day or on 17th of April 2025 on bail, the person who had been remanded by the court martial, as it then was, for 1,500 days, that is 4 years. The court was presented with the same argument as has been presented here, that days of the court martial should not count. And my Lord, Your Worship, the court in debunking that argument used section 17 as then was. Your Worship, that section is the equivalent of section 9 of the Magistrates Courts Act, under which this court is set up. And Your Worship, for clarity, I will read verbatim. Right, Your Worship. It says, the jurisdiction of a magistrate's court shall, subject to this act, and any other law limiting or otherwise relating to the jurisdiction of that court or the presiding magistrate, be exercised in conformity with the law with which the High Court is required to conform in exercising its jurisdiction by the Judicature Act. Your Worship, section 17(2) provides for the inherent powers of the High Court. And this section is telling you that you have the same power. Your Worship, in applying that section, the judge here said, Your Worship, again I will read for clarity. At page 5, Your Worship, because of time I've rushed, that is paragraph 4. The court said, where a civilian was initially charged in the former court martial, any subsequent bail application falls within the jurisdiction of the ordinary courts, and an accused is at liberty to exercise that right to apply for bail. So, Your Worship, I don't know what counsel was submitted with this authority. So, Your Worship, meaning this application is properly before you. Where else do you want us to apply? In the court martial? And Your Worship, at the conclusion as was read by my learned senior, Your Worship, it is paragraph 4 of that judgment on page 5, the ruling. After that finding, the court went on to find that all the 1,500 days spent on remand on account of the court martial were actually days that are counted. And the court counted them and released the person on bail. So, Your Worship, being the position now of the law being, you cannot say that proceedings of the court martial are not counted. In any case, Your Worship, this is what, if you rule like that, this is what you're going to say. That the people who are serving time now in the prisons, because of the court martial, are actually free. We would be glad to take that finding. But that is essentially what we say, that whatever they are serving is not counted. So let them be released then. In any case, Your Worship, as my colleague is having it, where did the state pick the accused persons to bring them here? Did they pick them from their homes? Did they pick them from their workplaces? They picked them from Luzira government prison. They are serving time on account of the court martial. So, Your Worship, again, as we close, so that I cease to defraud my learned senior, that time is as good as time that they have spent when they came here. So, Your Worship, as I close, that is the submission I sought. And I seek the court to take into consideration that submission.
Your Worship, the issue of the 80 days has been tackled extensively by my colleagues. 180 days. I just wish to reiterate that Land Council for the State, Mr. Ubunkenke, conceded when he said that he would have no problem with them being released if the 180 days are met. In his view, the 180 days should start when the accused persons were brought before this court. Your Worship, my colleagues have cited authorities to show that indeed the courts of law have found that the remand period where there has been a court-martial intervention start from the time of remand by the court-martial. On that basis and on his own concession, the accused persons should be entitled to be released. We take it that his submission and his concession was based on circumstances where he was not alive to that decision, but it clears him lest he's taken to have allowed to have been released. He said, I have no problem if they have clocked the mandatory period, but they have not, because he said it's the magistrate's court, but that decision have been cured by the higher court. The second one, my learned friend, Mr. Billy Vumbuka, alleged that the DPP brought new charges. He did so in an attempt to nullify the custodial condition in which the accused persons are placed. Your Worship, under the Evidence Act, we are alive to the fact that the court takes judicial notice of documents on the court record. Your Worship, in the criminal application number 1 of 2025, I'm referring to my colleague is unhappy, but I'm referring to that notice of motion which, Your Worship, was endorsed by the Chief Magistrate. So it was owned by the court. It is a court record.
But did I submit on this?
Yes,
No,
Your Worship.
without due respect. Without due respect.
I request that he listens to me. And if I may just, Your Worship, put the matter in proper perspective. The application was brought at the instance of the land chief state attorney and was pursuing this application with vigor. So he's alive to this application. It's an application to access, and he brought it up. Your Worship, that notice of motion, as it should be, is supported by an affidavit of DIP or Dick Benedict. I would want to refer to the first 4 paragraphs.
But you want to think this is the way. I know the court has jurisdiction to overrule prosecution. I know that, Your Worship. But again, as prosecution, we cannot see when there's something wrong ongoing. First of all, we never responded anything in respect to that notice of motion in our response. I believe that my senior colleague should be making a rejoinder on specific issues which we raised in our response. Yes, that was not part of it. Secondly, he's raising other issues. He's now going into details of the affidavit, which was never part of our response. Your Worship, I respect my senior colleague. You understand? I do respect that, but being senior is not a prerequisite to go into details which were never brought up at any point during the trial. We never talked about it. I pray that this cause prevails over him to speak and submit an address on other matters which arose in the reply.
Your Worship, if I may, I am responding to the contention of the DPP having brought you. Absolutely. Yes. And I'm mindful of the fact that again, the affidavit my colleague is objecting to wantonly was drawn by the DPP. It states as follows, my Lord, Your Worship. In paragraph 2, yes, I'm just referring to my Lord, it says that the respondents are accused persons in Accra Criminal Court number 8 of 2025, which is the matter before you. The respondents were previously charged before the General Court Martial at Hajji and were being tried there. However, following the decision of the Supreme Court in Constitutional Appeal number 2021, Attorney General versus Michael Kabasiguka, the case was transferred to the Uganda Police. The Uganda Police took over investigations of the case on 11th Feb, and I was one of the officers who was assigned to investigate the case. The case was transferred. It is in the affidavit. Your Worship, when you transfer, let's be practical. Your Worship, if you transferred your car to me, I inherit it. God forbid. So, there are no fresh charges. As a matter of fact, and my learned friend referred to the Supreme Court decision. The Supreme Court decision actually directed that the files be transferred. It did not direct that those charges be dropped and fresh charges brought. So it is coming as a transfer. It means that the process is continuous. He cannot allege that these are new charges. The transfer, incidentally, and I reckon my colleague knows, is a simple English word, not a legal one. The matter acquires a new conductor. We have the conductor in the General Court Martial. Now we have the conductor, fortunately or unfortunately, who is Mr. Bilifu. And it was a transfer. And the other one, indeed. Your Worship, in trying to disparage that article, he said it's not applicable because of the charges. One of the charges against the accused persons in the General Court Martial is the offense of treachery, which under Section 129 of the UPDF Act, the penalty is death. Applying it, I don't know the Latin word where I should be mutantis mutandis, but transferring it means that it is an offense because of the penalty, which cannot be tried by a magistrate court. It can only be tried by the High Court. And Your Worship, it should be remembered that before the decision of the Supreme Court, the General Court Martial insisted that it was equivalent to the High Court, i.e. it was the High Court of military law, only that now it was charging civilians. It is therefore a lame argument for my colleague to contend that because it says High Court only, and referring to that Section 9, this court is bound not to be mechanical in approach. If an offense in any other court has a penalty of death, it means that if it is transferred to the civilian dispensation, it can only go to the High Court. It therefore becomes an offense which can only be tried by the High Court in its original jurisdiction. As I wind up, Your Worship, my Lord, Your Worship, Mr. Billy Bumbuka tried to convince you not to refer to what we had said because the record of the GCM was not here. But in his opening remarks, he said that the accused persons were arrested in November and arraigned in the GCM. He did not furnish a copy of the record to support his allegation. So I don't know whether his submission is gathered from the sky or whether it should only be taken when he submitted. It is not denied, and my worship is in the affidavit which he responded to. In paragraph 3, the affidavit of Kkooti, which hasn't challenged, that in fact they were taken captive on the 16th of October and produced in the paragraph 4 in the GCM on the 20th of November. applying the decision of Mr. Justice Mwata, the period of remand then starts to run from the 20th of November 2024. Your Worship, again, my colleague referred to Article 26.3 not being applicable on the premise that the committal papers were ready. The plain reading of Article 23.6 says before committal. It doesn't say before availability of committal papers. So again, my colleague Mr. Billy Vumbuka knowingly is trying to read into the Constitution things, they are not things which don't exist. The clause is very specific. And incidentally, the release of the accused persons on mandatory bail does not stop the committal, because they can be committed while they are on mandatory bail. So there will be nothing to stop this court from releasing them on mandatory bail, as they are now entitled to, and then they return to court for its directions for committal. And Your Worship, that could be one of the conditions. We release you today, return tomorrow for committal. Yes. It is within your power. It is not within the wishes of Mr. Billy Vumbuka or the state. Your Worship, I conclude, because sister and brother magistrates have declined to grant this order. They have shied away on the basis of matters being of a capital nature. Others have shied away on the basis of fear of what will happen if accused persons rightly entitled to mandatory bail are released. Your Worship, decisions of this nature in these times can be challenging, but that is why we are in a court of law. It is the reason why disputes, however outrageous, however grave, however serious, are brought to a court of law which is independent and which is free from influence and free from fear. Your Worship, we cite in the journal The Discipline of Law by Lord Denning. Your Worship, it states this, I'll just read it. Just to comfort the court that despite the circumstances, it is bound to exercise its duty. That if the powerful still abuse their powers without restraint, it is thanks to the dominant influence of timorous souls. Timorous souls, my Your Worship, speaking to judicial officers of courts who shy away, exercise the power granted by them granted to them by the Constitution because of fear. Bold spirits will not let such abuse stand. Any rule of law which impairs the doing of justice, they will do all they can legitimately do to avoid that rule. They will even change it so that justice before them is done. We therefore appeal to this court. The Constitution commands the court to release the accused persons on mandatory bail because they have met the standard, subject to the conditions which the court imposed. That circumstances are dire and perhaps strange things will happen, that is an after event. The role of the state, as I conclude, Your Worship, was very simple. Under Section 76, the duty of the state, Mr. Bilbuka, my brother, was to demonstrate two things. they are entitled to be released unless before the expiration of that period they have been committed. In this case, there is no committal and he has conceded. He has his papers ready, perhaps in his court, but has not done the committal. 2, the magistrate is satisfied that it is expedient for the prosecution, for the protection of the public, that the accused persons should not be released from custody. He has not demonstrated anywhere that these are a danger to the public. He has not therefore discharged his burden in any way, despite the time quote unquote reviewed. In any event, your brother magistrate allowed the public to interact with the accused persons and they were not endangered. To the extent that Mr. Ubunkenke has not done anything to dispel or to prove this guilty, it is our prayer that the inevitable must happen, that the accused persons are released on mandatory bail, subject to the conditions which the court shall fix. Your Worship, we beg your indulgence. My colleague holds a firm view that there is something we haven't covered, just to afford him 1 or 2 minutes to cover that. He has stood up, he says he has been piercing me to say there is something I've missed. I apologize.
Just 1 minute.
Much obliged, Your Worship. Your Worship, all matters have been canvassed. I would just want to add in reply to Mr. Ubunkenke's contention that state is ready to commit, and therefore it should be reasoned as to why the court should not admit the applicants on bail.
I think it should be very clear, otherwise you have nothing to say. My argument was clear.
Let him submit and then court will look at his
Much obliged, Your Worship. Your Worship, the authority I would want to cite to this honorable court is a high court authority by... Yes, Your Worship, because it's instructive. It's instructive on the issue of... Your Worship, if I may, it's instructive. The authority is instructive, and I can yet only submit an authority report. It's instructive on the issue of the prosecution being ready to commit amidst a bail application, a mandatory bail application. And this authority by Justice Collins Aslim at the High Court of Bulu, where the persons were charged with aggravated robbery, stated that even if, because prosecution was requesting that it commits before the mandatory bail application is had, the learned justice had an occasion to say that even if the prosecution had papers in court, as they had then, you cannot overlook the provisions of the Constitution for entertaining and granting an application for mandatory bail, and therefore it can be done later. And I pray that this authority is admitted for its of binding nature to this honorable court, for it is a high court authority. And the authority is Andrea Charles and others versus Uganda, miscellaneous criminal application number 3 of 2024 at the High Court sitting in Bulu, in Arua. Your Worship, we shall provide the authority. My friend has stepped out to print the same, and court admitted the applicants on bail, even when prosecution had papers in court saying that it was ready to commit the applicants. Much obliged, Your Worship.
Your Worship, we shall use less than 2 minutes. And in these 2 minutes, granted last year, we shall instead characterize the submissions of Richard Ubunkenke and those that suffer from lack of focus and clarity. And also outrightly, we associate with the submissions of Council Martha Karua and Frederick Mpanga, the other councillors.
With the leave of court.
No.
No, court is the
No, I'm not granting that.
kale kitwanange tuli mu kulinda kati mulamuzi amaze okuwakana olulimi lw'abalooya kati we are waiting for the judge ekisembayo mbasaba musubscribing please if it is your first time here people watching us from Kenya. If it is your first time to watch Extreme Media UK, please you subscribe. Yeah, make sure you subscribe. And Besigye dakiika zetuva okuba ku period gyetutandikiddeko ndaba nti ne data yandibanga ali mutuwoninga kuba tugubyayo ibiri and 54 minutes already kirabika data ali mutuwoninga si kyembadde nteesa kyekino yenna Good Samaritan ayambe ataase eggwanga muteeke ku namba ezaawo waggulu zempininzeewo tusobole okumalako n'ekkooti eno kubanga tugeze tugaanye data bampoonyeze
nange bangulire ku data ne pgfax mungulire ku data
tuli mu kulinda mulamuzi. We are waiting for the judge. Kayinzi data weddako. Banange data aweddeko mumpe ku data.
On the basis that these persons have clocked the 180 days spent on remand before commission. The defense has made detailed submissions that Article 23(6) is a command of the Constitution that this court does not have the discretion but rather set the terms for the bail. Prosecution in reply submitted that the charges that were charged with murder, court-martial seized and were terminated by the constitutional decision of the Supreme Court. Prosecution submitted that the accused have spent 3 months on remand and not 180 days. The defense in rejoinder submitted that the proceedings of this court are a continuation of the proceedings of the court-martial and thus the days spent on remand should be considered from the time the accused first appeared in the court-martial. The defense has provided a number of authorities to buttress submissions for grant of mandatory bail under Article 26 of the Constitution. This court is mindful of the provisions of the Constitution, Article 26. However, this court also takes cognizance of the Constitution bail guidelines for courts of judicature 2022, which commenced on 28th June 2022. The charges that accused the charged with a capital in nature. Practice direction number 10.3 of the guidelines provides that for avoidance of doubt, mandatory release on bail for offences triable by the High Court, the Constitution, and Article 26 of the Constitution shall be granted only by the High Court. This provision asks the jurisdiction of this court to grant the applicants mandatory bail. The fact that this court's jurisdiction is ousted by the practice direction number 10.3, this court cannot go ahead to determine whether the days on remand cover the period before the accused were arraigned before this court. I wish to also add that all the authorities cited by the defense are authorities of the High Court, which granted mandatory bail in capital offences, which is well within its jurisdiction as per the bail guidelines. For the above reasons, this court lacks the jurisdiction to grant the applicant's application for mandatory bail. The applicants can apply to the High Court for mandatory bail.
Your Worship, yes, Your Worship, as prosecution, Your Worship, now that this court has pronounced itself on that application, we intend to make an application to just before Your Honor, I'm intervening upon the rules. I'm intervening.
Let me hear what you have to say. Let me hear.
Your Honor, thank you very much. We have had the ruling and we respect it. And the immediate response, Your Honor, for even the state can come in, the guidance you have cited, the immediate you cited guideline 10, guideline 11 says that once you do that, then 11.3 says that you immediately transfer the file to the High Court. I pray that you abide that guideline and recruit. Pardon?
Read it, Baba.
Yes. This is the guideline that the court is using, so I would want to read it. The procedure for bail, that is the heading. A magistrate's court shall submit to the High Court files of persons
eligible for mandatory bail. Subsection 2, an application for mandatory bail in the High Court. Yeah, so basically that is subsection 3 of section of sub-guideline 3 of guideline 11. It says that this court submits this application, this bail, this file transfers it to the High Court immediately, that the accused persons before it are eligible for mandatory bail. And it is our prayer that they are eligible for mandatory bail.
You want to join the issue again, citing those guidelines. Because those guidelines, just to put it, create a link, provide that an application to mandatory bail in the course of this meeting will be oral. We have made the oral application. The court has found, as it did, that it does not have jurisdiction. It has not found that the accused persons do not qualify, meaning that the matter now, the issue, is about jurisdiction. Therefore, and relying on the same regulation or guidelines, 3 reads, a magistrate court shall submit to the High Court files of persons eligible for mandatory bail, and upon receipt, the registrar shall cause the files be registered in the bail register. To that extent, and guided by the first sub-regulation, which provides that applications in the magistrate are oral, ours is an oral application now, given the finding of court, for the file to be forwarded to the High Court, which is a command to the registrar to enter it in the bail register so that that application is considered. It appears to be mandatory and not discretionary, so we reckon that once it's been referred to the court, it is bound to abide. I reckon that the response from Mr. Obed will be to affirm the mandatory command so that going forward, the file proceeds to the High Court. Most of them.
Much obliged, we think that it should be on record of the lower court's record, or when we go to the High Court, it will come up, that we specifically contested the selective application of the bail guidelines.
I think that one that is a critique.
It's not
that is a critique of the ruling which you are not contented with.
It is
You
fine.
cannot have it on record now. That's a wrong procedure.
Just summary.
Your Lordship, we pray that the court grants him on paper, because we are now starting
Make a submission.
Your Lordship, it is on record that we filed the bail application in the High Court. Your Lordship, the bail guidelines, under specifically guideline number 8, provide for time to dispose of the bail application. Your Lordship, it's now 1.5 months, which is over 30 days. Yet in the bail guidelines, they clearly state that a bail application shall be disposed of within 30 days upon its filing. Your Worship, up to now, our bail application we filed has not been fixed or even high. Now, what we want to be on record is that in this ruling, or in this trial, in this case, there has been selective application of the guidelines that we are using in bail. Because if this court is applying them to say that we must go to the High Court, But the High Court where we are is not fixing our application within 30 days as mandated by the guidelines. We submitted that is a clear and clear selective application of the guidelines. And my learned brother now can come in emphatically to state what he wants to state.
Your Worship, just precisely, and this is in addition to 11.3 that has been quoted by. Your Worship, precisely, this is in addition to 11.3 that has been quoted by Council Harold Chiza and Council President Parliament. We go to 10.2. I shall read. In the case of a person who has been on remand for 180 days in accordance with Article 236C of the Constitution, the magistrate court shall immediately refer the file to the High Court.
Yes.
Your Worship, that's my humble prayer that the file be referred to the High Court.
Right now.
Again, this is a total misinterpretation of the provisions that my colleagues are relying on. One, for a magistrate to refer a matter to High Court in case of mandatory bail, that court must have pronounced itself on the fact that the applicant or the accused person has clocked mandatory bail in custody, which is not the case in this regard. It is not a duty of this court to pave way for the release of the applicants. The applicant has a fleet of senior lawyers who can move High Court in this regard. There is no basis for this court to refer this matter to the High Court because the applicants have not clocked mandatory period in custody. You cannot have a matter in February and then in May you're saying the applicant has clocked mandatory. This is simple mathematics. This court has no jurisdiction. In other words, that application is misplaced. If the applicants wish to make an application before High Court, they can do it on their own initiative, not through the vehicle of court. That court should move them. And it's not, by the way, it's not the fault of you, Your Worship, that the application which my brother Brian has been submitting upon has not been fixed. And therefore, I don't want to use a harsh word. I want to use it. But it will be, but what shall we give them a lot of time? When it comes to me, you give me 1 year. Speaking with this. This request is misplaced. They know where to go in case they want the application to be fixed. In summary, Your Worship, I pray that we dismiss that application and we proceed. We proceed with the amendment on the charge sheet and other processes for today, as prosecution actually addressed.
Very brief rejoinder. We have cited the guidelines. We cited the requirement of the court to submit the file. Unlike my colleague, Mr. Philip Mboka, the court did not say that the 180 days period had not been met. But Your Worship, touching from 3, where a magistrate shall submit to the High Court files of persons who are eligible for mandatory bail, And upon receipt of the register shall cause the files to be registered in the bail register. 4 says the register shall list the files submitted under subparagraph 3 for hearing by a judge. 5, which is very important, says upon disposal of the bail application, whether it may be granted or it may not be, the file shall then be returned to the magistrate's court to enable the court to proceed with the committal. It means that once you've applied for bail and the court has found as it has, that's a matter to the High Court. Once we have applied, in fact, Regulation 2 doesn't require that we apply, it requires that the court forwards the file. It means that because it is a right of the accused, all other proceedings stop until the matter of mandatory bail is handled. So again, the words in that resolution do not say may. It is shall. As lawyers and advocates who appear at the bar, we are enjoined to be officers of court. We are praying, Your Worship, that you do not allow Mr. Billy Vumbuka to mislead the court and yourself. So, we are therefore saying that the command is that the file be forwarded. We also refer to the same regulations, which is 10, Rule Regulation 10, Sub Rule 2. Person who has been on remand, which my colleague referred to, more than 100 days, the magistrate shall immediately refer the file. Mr. Bill Vumbuka will have his day in court to make all the healthy submissions. We are saying that this court, its ruling, now does not have any matter to deal with this one. Let us go. We shall return when that matter is. And perhaps to add, we are certain that when we go away for a bit, it will allow this court some respite. So we pray that we go to the High Court to determine that right which cannot be abrogated. Then we shall come back when the court has pronounced itself on that matter.
Just one point. We appreciate your ruling, although we were of a different mind. But now that the court has decided to adhere to the guidelines, we are asking the court to be consistent and therefore in line with guideline number 10.2, as urged by my colleague, to immediately refer the file. It would be quite untidy if the court was to adhere to the guideline and then not adhere to the guideline. So for the sake of consistency, predictability, and the appearance of justice being done equally across the board, let this file go to the High Court.
Guys, please wanange mungulireko data agenda kukuwako wana. I request. Nange nsaba mungulireko data ngokuluga wankumi bibi ayi have used 50%. So I request you, let anyone buy send me that on those numbers. Just deposit, please. I want to finish. Yeah, the Kumitan. Yeah, the Kumitan on MTN. Please. Those numbers and pins. I beg. Vanga tugenda kuvaako kati. yambongera okubajukiza mu subscribing tubane tuweze subscribers nga 30k. Subscribing, you subscribe if it is the first time here. Mwena mugiliking muliko bangi, lwaki temulayikinga live byaffe? Mwena abagiriko mugiliking, you like the video please, you like the love. Kyenyongera okubajukiza temwerabira ku subscribing please. Make sure you subscribe. Tovaawo nga tusubscribinze ate omakinga sure nga oturning on ka notification bell awujja kuba updated ku buli kimu kituteekayo. Bananga muguleyo ka data ku namba ezo zempinizeewo tumalirizeeko Kkooti. Yadde ezibeerawo zonna mutege ku namba ezo. Njagala kumaliriza Kkooti. Uyinako sente mmeka ku account?
Yadde nolwata n'okulabika olali.
Sorry.
The court has made its decision on the application for mandatory bail. Court having ruled that it cannot grant the application for mandatory bail, the defense has submitted that this court should, as per the guidelines, submit the file to High Court for the application for mandatory bail. This court has not pronounced itself on whether the accused persons have clocked the period of mandatory bail. And as such, this court cannot cause the file to be forwarded to High Court as provided for under guideline number 11. Considering that prosecution intends to amend the charges and make other proceedings thereto, prosecution should proceed with the application for amendment to the charge sheet.
Most of brevity. Your Worship, before my colleagues commences, our instructions are to seek a revision of that order.
It is well. If the revision will be made, but for now we proceed.
When we ask for a revision, because the decision continued after we have been making a subject of the revision, it is not proper for the court to continue the trial. Our position is strengthened by the Supreme Court decision of Charles Onyang Ogo and Andrew Mwenda versus the Attorney General. Mulenga J. SC, as the name was. Yes. The import of this decision is that when a process in the lower court is under challenge in the higher court, the lower court must wait lest it proceeds and this decision or procedure is found to be faulty to the prejudice of the accused party. So our request, because we have sought a revision under the Criminal Procedure Code, we are referring to 848. We are asking the court to review the file, including the decision regarding bail, the mandatory bail,
You're requesting?
Yes.